Hi, everyone. Welcome to week 10. My name is Samuel Gabriel. I'm a final year student. I picked IP trolling as a discussion that I'd like to present on because I find the topic and the concept fascinating. I find the concept of IP trolling and copyright trolling particularly fascinating. And on Moodle, I posted a copyright trolling business plan last night for everyone to enjoy. And if you want to, you can implement it. But I did make a note that it was my IP and that you need to come and get some sort of license from me in the first instance. Rebecca is my colleague as well. And Rebecca and I, we've been bouncing some things off each other this week, ideas, and it's been a bit of a challenge. Rather than just sort of talk about the notes, I'm going to talk about... I don't know where Mummy is. Give her a call. Maybe Rebecca, you'd like to introduce yourself at this point in time. But what I was going to say is that I wanted to just pick a couple of areas of IP law, IP trolling, and talk about them tonight, and maybe go through some of the ethical and commercial businessy areas of the business plan that I put together, as well as the recent Dallas Buyers Club, which it's probably been talked about a bit, and I do apologize to all my colleagues for not attending every session. But there's been a development in that today with a law firm offering pro bono advice. And I just want to share that as well and talk about that. And that's in conjunction with IINet, who have formed that sort of a team. So that's me. And Rebecca, if you want to talk about yourself, and then Greta, I understand if she's able to as well.
Hi everyone, I'm Rebecca, obviously. Sam and I have been going back and forth about this. I think we have some conflicting ideas on the ethical side of things as we've been talking about it. But I think we're just going to go over sort of what we've researched and what we've come up with. I'm definitely not as knowledgeable as Sam is, I've realised, probably just coming down to his experience in it that I don't have. But I've done a bit of research and I've come up with sort of what I'm interested in. So I guess, do you want me to start and just go over sort of what is an IP troll and everything, Sam? Yes? Okay. So basically, IP trolls basically claim rights to intellectual property against large businesses by threatening litigation and the idea of forcing them to settle out of court. So basically it comes down to, can we be bothered to pursue this into court? Half the time it's going to be more beneficial to pay you out than to go into a court battle, regardless of whether or not, you think it's just a load of crap, basically. What's the point if you could just pay them out and be done with it? You might as well cut your losses. So that's sort of what patent trolls do. They'll put a patent out there. They have no intent to use what they're patenting, but basically they just want to use it for litigation. They have no other intention to actually create anything or, to do anything with it. They're just basically hijacking everyone else's ideas for the purpose of litigation. So that's what I've come up with of what an IP troll basically is. Do you want to add anything, Sam?
I think... Close my door. I think the IP troll, the idea... Sorry, I've got two kids. It's just awesome. The definition of IP troll, and I'm going to use a lot of layman's terms, is a legal shakedown merchant. That's my view on it. It's a legal shakedown. It's statutory extortion. That's how I looked at IP trolling. And if I was going to do it, that's the framework I'd be using. Like I want to call it for what it is. I'm coming to you for a copyright infringement that may appear innocent and may indeed be innocent, no malice intended, no knowledge, constructive or otherwise, that you are undertaking, that you are committing this infringement, but I'm going to shake you down anyway, because I'm going to get something for my client, but I'm also going to be remunerated out of it. And if I'm effective at it, I can make a business out of it. Yes. Scott has said this is analogous to a protection racket. Take issue with the word racket because it's not illegal. It is still legal. It's probably the lower end of the spectrum. But I've come across IP lawyers, and I've been involved in a recent IP litigation or out-of-court litigation settlement. And it is just as nasty as anything else, except the rules are very grey. It's a lot of big words, a lot of threats, a lot of, if we do take this to court, you could be liable for $500,000. So the average person would think about, oh my God, I've just started a company or I'm conducting a business, and I didn't mean to infringe on somebody's copyrights or IP, but now I find myself liable or potentially liable for using an unlicensed product or report or something. So that's all I have to add at this stage, Rebecca. I'll be conflicting with you later on in the evening. Greta, would you like to add anything to the chat? All right. Rebecca, do you want to take it from here?
Okay. Well, I found a quite interesting website, which I'll try to link you guys to now, if I can put it in the chat. If you all want to open that and have a look, just about sort of patents and the limits that it puts on medicine. I thought that was quite interesting, considering. So what it basically says, it's in regards to the Intellectual Property Law Amendment Bill. So it's basically talking about being able to use a patented right without, needing the permission to do so, because when it comes to medicine, it's going to have an impact if we can't use, that information and that patented thing, it's going to have a huge effect, especially with things like medicine. So I found that really interesting. I don't know if anyone's reading it currently, but that's where I took more interest in. Looking at it now. So I don't know if anyone has anything to add to that, like what their views are on that, because I think, I definitely agree. I think that we should be able to, use a patented thing when it's going to help others. Like, I think that's quite a big thing. So I don't know what anyone else thinks, but I would like anyone's input would be great.
I suppose I'm thinking back to last week's topic a little bit, and about how the courts consider clothing to be too utilitarian to actually copyright or allow to have patented. And in that YouTube, that TED Talk talked about how it basically meant that instead of it stifling innovation, it encouraged innovation, and that the argument that copyright would need to exist in order to protect people so they would get profits from it, so they do it in the first place. And I'm wondering if maybe when it comes to medicines, but is there not an argument that they would have as equal amount of utility as clothing would? And maybe there should be, I suppose, little to none copyright protection on them, maybe. What do you think?
Yeah, that's good. I have no idea. I don't know the answer to that. I wish I did. But that's definitely a good input. I hadn't thought about it that way. So I don't know if anyone else.
The R&D that goes into creating medication is certainly a lot more, you'd think, than the R&D that goes into creating the next Chanel scarf, even though they probably cost $1,000 each, right? But certainly that there's got to be some return for for that investment. Look at instead of, when you think about pharmaceuticals, instead of thinking just about medication, think about a pharmaceutical company like ResMed, which is publicly listed on the New York Stock Exchange and the and the Australian Stock Exchange. They create the sleep apnea devices. They've got like 1 million patents for everything, from the ring to the tube to the mask to the radius of the mask, the thickness of the silicone, all that sort of stuff. Its main competitor is Philips Respironics, which is owned by Philips. Philips is by large double or triple the size of ResMed in terms of its financial resources. ResMed was started by 2 Aussie blokes in Melbourne, and now it's a global juggernaut. But surely the R&D and the development in that, although the product helps people, although the product can save people's lives, their facility's got to cost something. The medical engineers that they employ have got to cost something. So what's to prevent me, Sam Gabriel, from taking their mask, going offshore, reverse engineering it, and producing a mask at a quarter of the cost? I haven't spent that money. They've got to sell it at that point, at a price point, to get some return on investment. So it would be good to get something back for that. So I'm kind of open that it is good to have that open and to reduce the enclosure, but the business person in me, and you can blame corporations law for this, I want to see a return. I want to see, show me the money.
So essentially, Sam, and I have to agree with what you were saying, things should be more protected the greater amount of capital is required to bring them into existence. Should that be an appropriate test that should be written into our current trademark laws, or do you like the balance that was struck currently? Let me bring it back to this topic that we're talking about at the moment. We're talking about patent trolls and the rest of it. So the 2 Aussie gentlemen who are developing this device, say Philips, even though they haven't made anything yet or brought it to market, have general patents on this technology. What protection is there currently for those 2 gentlemen during their initial stages to not get wiped out or sued into oblivion, even though through Philips being a patent troll?
I think that their protections are the same protections that any sort of inventor will have in the first instance. I'm talking more about they've got something that they've developed. It's in its maybe 4th or 5th iteration. It's been tested, it's proven, it's gone through clinical trials, it's hit the market. They want exclusivity for 7, 10, 12, 20 years, whatever they can get, right, in order to see a return on that and to learn from it and to build on it. They probably, who's to say that enclosure doesn't allow innovation? So I could take your product and try to innovate on it or replicate it, but I haven't seen and gone through the testing that you've gone through for the last 10 years of R&D to know where the flaws are, to know where the faults are. I may replicate it, and I may replicate it badly. And a good example of something being replicated badly is the damn it, what's it called? It's that blender that costs like $1,000. Does anybody know what that is? Everyone, see, no, you know. What's it called? Thermomix. That's it, Thermomix. Right. So I found like that's it's a blender for $1,000. Who does that? Good Thermomix people watching YouTube. But there is a product which is imported from China, which I saw at a market in Western Sydney, and it's selling for $150. And it looks like Thermomix. I think it's called ThermoWiz or ThermoWix with a WICKS. And I spoke to the lady and I said, "What does this do?" She goes, "It's the same. It's just got a few less settings. You know, it's okay." And I said to her, "How do the people at Thermomix feel about their intellectual property being replicated?" And she looked at me and she said, "Do you want to buy it or not? If you're not, go away." But that's a good example of something that has not been, it's been replicated cheaply, It's come to the market. There's probably going to be 100 people who are going to go buy it, but they're buying it because it's cheap. They're not buying it because it does it's not the same as a Thermomix. And the people at Thermomix could probably back their product based on their R&D and their testing and their investment and say, yes, we know this machine will last, or this motor will last for 3 years or 2 years or whatever. And yes, there's consumer guarantees, but go and find the people of Thermowix. Go and find these cheap importers, and you won't be able to find anything. And there's no guarantee. So I don't know. Scott looks like he's got something on Thermomix. No, he doesn't. No, he's good. All right, Rebecca.
I do have one thing I wanted to say, which is, I'm just a bit behind in the conversation. One thing I didn't mention in the course notes that's kind of relevant to this is the licensing schemes under the Patents Act. We have a compulsory licensing scheme under our Act, which says if you don't actually exploit a patent in Australia, people can apply to have a compulsory license granted to say, well, you're not using it, I want to be able to use it, and then there's terms for payment. But the more intriguing thing is the UK law has a thing called statutory licensing, which is slightly different, and that's where a product is available, but it might be being sold too expensively, and the government then compensates the patent owners for the expense. So if someone, for instance, said, I've got a cure for HIV, but it's going to cost $1,000 for each treatment, there's this option under the UK laws, and it's argued that we should have it under our laws, that the government should be able to say, okay, you're going to sell it to Australian people for $100, but we're going to pay what's fair. It's probably not 900, but we will compensate you for the loss of that revenue. So that's an interesting way out of that balance between the rewarding the people who invented and developed a product, but also making it available if it's something that's so important from a health perspective that everyone have access to. So I know I'm 2 steps of the conversation behind, but I just thought I'd fill that in.
But isn't that what the pharmaceutical benefit scheme essentially does? Just does it through. Okay, yeah.
Now, I don't know what you want to talk about next then, Sam. Anything in particular? Oh, I don't know if Greta has anything to add.
I think Greta's left the conversation. Or
Has she really?
She pops in and out.
Oh, okay.
Well, my screen's telling me that she's not here. But,
she's going to record a video for us because her internet connection is just dying on her. So she'll do a video and I'll put the link up for everyone.
Cool.
Okay, perfect.
Well,
can you run through your business case? Did you read that?
Business case. How many of you, by show of hands, had a look at the business case that I put up? Rebecca? Scott, I'm devastated.
Yeah.
You've had a look. All right, cool. Well, I'm going to attempt to share my screen. What am I doing? I want to share. What am I sharing? Yes. Okay, so what can you guys see? Can you see my business case? Business plan? Yep. Okay, cool. So I took the task quite seriously and said, if I was gonna run this, how would I run this? And I fell back on my training as an engineer. So I'm a solo practitioner consulting engineer, and I work with a lot of developers in residential development, subdivisions, and road upgrades and infrastructure. And I meet a lot of startups. And I thought, geez, how are these guys funding their startups? By the time we purchase professional indemnity insurance, public liability, and buy a decent laptop, we're 10 grand down the hole. As a startup, you've probably got to shell out 50 grand. And I thought, that's 50 grand for just hardware setup, office space, etc. And then software licensing. Each computer probably needs about maybe 20 grand worth of specialist software. So I thought, I'm going to try and see how I could come after an engineer. And I came up with like a purpose for the trolling plan. And I said I'd focus on AutoCAD, which is an Autodesk product. It's a computer-aided drafting software. And it can be illegally downloaded. And for the purposes of this assessment, I did a Google search on AutoCAD torrents, and there was like 500 pages on it. So I thought I'd start a fictitious law firm and call it the Devil's Advocate. And I'm going to represent something called the BSA Software Alliance. So if you Google BSA Software Alliance, this is a real thing. And they represent Microsoft, Autodesk, Cisco, and a lot of big end companies. So I pretended I was going to be acting on their behalf. And my first step was, how do I find these new startup firms? There's no ASIC search that says startup engineering firms. So I thought I'll go to where they would be doing their work. So the council websites. So I've put a link to 4 council websites here. These are active links, and they take you to development application tracking. So this will, and you can type in subdivision in any of these, and it'll take you to a list of approved subdivisions by council. And all you have to do is look at the engineering reports or the engineering drawings and determine who is doing these. So a good IP troll will spend maybe a couple of days and just looking at all these and making a list of subdivisions and 2-lot subdivisions. We're not concerned about a person who wants to extend a pergola. We want some meat. We want some money out of this. And then focus on firms that are less than 15 staff and generally started within the last 5 to 10 years. Probably last 5 years would be better. And focus. And the reason I picked the Hills Council, Penrith City Council, Blacktown Council, and Fairfield City Council is they're in what we call growth areas or growth centres in New South Wales, and they have large industrial, large residential lots. So I said we'll do an ASIC search on these companies, and we'll get the details from the title blocks on the drawings or the reports. We'll do a profile on the directors, age, education, home address, and formulate a bit of a socio-economic profile. I'm getting a bit CSI on you. It's cool. And then I'd search LinkedIn, which is a social networking site, for a professional social networking site, and try and find out if those companies have LinkedIn pages, and try and find out if there are any ex-employees. And hopefully there's a lot of pissed off ex-employees. I'll make initial contact with them, tell them I'm investigating, I have a preliminary inquiry, your name won't be used at all, and lull them in a false sense of security. And then I'll ask them general questions. Look, I'm thinking of working with this company. How big are they? Do they have many designers, drafters? And someone will provide some advice or a lead. And then I'll latch onto it like a leech. And then I'll pick the likely or the soft target company. Now, being the representative of Autodesk, I can actually go back to step 1 with all the companies that I found and ask Autodesk to give me a reverse search on whether these companies have licenses, which they'll come back and tell me, no, your company does not have a license. And I'll go, that's beautiful. So I'll bring an action, and I'll begin action and representing Autodesk now. So I'll write a very lovely letter to the director of the company, who I've got an ASIC search on, and I know his home address and everything. And the letter is just general. I'll just tell him, BSA has received information to effect that your company may be using copies of BSA member software on its computers that exceed the number of authorized copies that you're to have. And this includes, but is not limited to, Autodesk software products. And as you can see, I'm being very nice, and I've given them a request that they provide us no later than 5 p.m. on a Friday. And I'll generally make it difficult, give them 2 days or 3 days to give me some information. So they can scramble to contact their lawyer. Their lawyer will want a copy of the letter. Their lawyer will want to think about it a little bit. By that time, the Friday deadline is passed, and they're in damage control. I'll request the number of BSA software installed, licenses held, evidence of licenses. So if they tell me, yeah, we've got 5 AutoCAD licenses. Okay, show me a copy of the AutoCAD invoice or the supplier invoice or the license numbers. So you can actually buy AutoCAD online from Thailand for $45. And I had a look at that before I came online today. And it gives you a serial number, but it's an unauthorized copy. It's not from an Autodesk reseller. So on balance, we ought to know that this is a dodgy copy that we've just paid $45 for. My comment on this was that this step is what I called the shakedown technique. In essence, this is where the ethical line is marginalized. These people have done nothing to me. These people have done nothing to anyone. They're just going about their business. But I'm now making life difficult. So from this, the fourth step is now I would, from my research and canvassing ex-employees, ascertain if they had a valid license, and hopefully, and this is what my discussion with a IP lawyer said, he goes, this typically prompts them to go buy a license, thinking that I'll go buy one and that'll retroactively cover me. This actually works to our advantage because it's proof that they never had a license. So I would write to them and say, we understand that your company employs 5 designers and draftsmen, and you purchased 5 licenses in the last 30 days, because they would have sent me a copy of their invoice. I said, and then and then this is where I really rip into them. And I tell them that, this is a blatant attempt to legalize the use of the software. And I would remind them that, my client is now entitled under Section 115, subsection 2 of the Copyright Act, that the infringement accrues at the time of the infringement. And we believe that this is the date of your company's registration. So not the date of the drawing, the company's registration, which is why we did the ASIC search. And we're of the view that your purchase of a license does not cure past infringement. It doesn't. We'll tell them we're entitled to compensatory damages under the same section, and we've assessed these damages at $30,000. And the table to do that is in the back. And lo and behold, I'll tell them, it's as per our entitlements under the Act and the principles set down in Autodesk Australia and Chung. We've done this before, and Microsoft Corporation and Easy Loan. So this is all we need to do is quote this case law and tell them that, we've done it, people, and we're awesome at it. Don't screw with us. Hopefully that'll prompt them to do that. But we'll also highlight that we think that there's additional damages for the breach. And this is the real money now. Under Section 115, subsection 4, that we're able to obtain additional damages to the breach where the breach was flagrant or for deterrence. And we'll allege, and it'll be our position, that if we do proceed to court, substantial damages will be given because they appear to have multiple unlicensed copies. AutoCAD is essential to their business operation, and that the management of their company was clearly aware of the infringement and failed to take any steps. Plus, they haven't provided any alternate software. They haven't told us they've popped down to Harvey Norman and bought Aussie CAD or something like that for $100 to produce their drawings. And also, in this fictitious scenario, it's a sole director of the company will say, we will hold you personally liable for the infringement, and you'll be liable to pay the damages to BSA. So we'll tell them, our demands are that by this day, you pay the infringement and damages, and you give us an undertaking that you won't do it anymore. You'll give us an undertaking that you as a director will refrain from unauthorized use, and that you as a company will allow BSA to come and audit you, and that we reserve the right to commence proceedings, etc., etc. And the table of damages is here. 5 copies of AutoCAD at $5,000 each, $25,000. is generally how much. And I've also listed a couple of 3 cases from the IPO, and that they talk about the damages sought, the compensatory, and the additional. So the compensatory damages are the Section 115 subsection 2 damages, and additional damages are the 115 subsection 4 damages. As you can see, Autodesk, when I did a search, there was like maybe 15 Autodesk matters. And it's for counterfeit software, breach of end user infringement. And this is just to put shock and awe into the recipient. So as a small consultant startup who's just trying to, break through a market, who's managed to employ 5 staff, and by my calculations, 5 staff, $30,000 a month circa billing, has a turnover of about just under $2 million per annum. Yeah, I'll shake him down for 30 grand and I'll get 30. No problems. So I said, given that the selection of the company is based on the likelihood that they do not have a license for the software, we would pursue some damages or a nuisance payment. Now, this is where it gets beautiful as an IP troll. Step 5, convene a settlement meeting, get the minimum damages plus some voluntary additional damages for pissing me off. And then the nuisance of the action would typically make the business pay something, because I'm going to slam my fist on the table. I'm going to tell him, do you think we care? Do you think AutoCAD's about this? Do you think AutoCAD knows that, paying devil's advocate barristers and lawyers and barristers is not costing them $10,000 a day? It's not about the $10,000 a day. It's about the principle. If they allow you to do it, they'll allow 10 other consultants to do it down the road. So we're going to take you for everything you got in the shirt off your back. To which the poor guy's probably going to turn around and go, I'm up. What do you want? And then we get some money. So in the interest of good representation, we would seek to allege more infringements based on other member software than we would if you've infringed on Autodesk. It's more than likely you've infringed on Microsoft Office as well. You've probably got a dodgy version of Adobe Acrobat on your computer. So we could probably do you again over and over again if we really have a flavor for it. And step 6 is pretty self-explanatory. Find a new company and repeat. And that is my strategy for copyright trolling. And from what I have seen, how do I stop this share thing? Right. So are we back? We're back. So from what I have seen from my own experiences, and from what I have seen from reading the material and trying to put myself into the shoes of somebody who wants to succeed at copyright trolling, like I want to succeed in doing this. That's the sort of strategy that I came up with. It shows a dark side to me. Don't be afraid, but also be afraid. But that's my contribution. Thank you very much for listening to me. I'm sorry for ranting, and somebody else speak, please.
Okay, so this is the part where Sam and I are probably going to fight about the ethical side of it, because he seems to think that that's like all well and good, and I think I have a slightly different opinion, so we're probably going to butt heads here. But I struggle to see how, with the rules and like things that you're bound by as a legal practitioner, how that it's bordering on vexatious litigation. Like you're just bringing, litigation for the sake of it. And I just struggle, I know you've got to act in the best interest of your client, which is where I struggle, because I guess you're obviously acting in the best interest of your client because you're going to get them as much money as you can. But, is that going to diminish public confidence in the justice system? And I don't know, I'm a bit torn between it, because I understand you're doing your job very, very well, Sam. But to what price is that?
That's a very good question, Rebecca. And I will note that upfront I said I think this is a shakedown. It is a shakedown. It is trying to put somebody in a corner in order to gain something out of them. But it's legal. And a firm like an organization such as Autodesk or Adobe, who have their products ripped off every single day, would want to see some return. And when you consider that the construction and the building and the engineering industry charge not as much as lawyers, but they charge quite a decent sum of money for a design. Some people charge by the sheet, and it could be like $2,000 per sheet. The outlay of a product of software is not a huge capital cost. It's an annoying cost to them. So I've just bought a $4,000 workstation or laptop. Now I've got to go spend $5,000 on software. For what? It's just software. Scott just made a note. Lots of big law firms using student logins to access LexisNexis. Is that true?
Yeah.
I have no idea.
You have a look at people's desks, and they have they've got sticky notes with the student's username and login, who's like an intern or something that they're using. It drives LexisNexis crazy because the firms are too cheap to buy licenses to access that stuff. So yeah, there's a lot of it around, and there's a lot of but we can't afford it. And this is I suppose a step better than buying something from Thailand, but it's not that much better when you've got a firm of 40 who are all using one student's login.
Yeah, I think is it unethical? No, it's not unethical in my view, but it is seedy. Is a better word to use for it. It is seedy. So I'm coming after you with an agenda. I have a motive to chase you down. I know your weak spot. And I'm also at a huge advantage because Autodesk, who are my client, have told me that XYZ Consulting does not hold a valid license. So really the first two letters are moot. They mean nothing. They're just to open a door, to lull them into a sense of, we just want to make some inquiries. We want to understand. We want to hear from you. But in reality, I know that all I want to do is come back to them. The purpose of the two letters is not moot, actually. I correct that. It's a fishing expedition. Because I can't come up with a damages figure unless I know how many infringements you've made. I can't just walk into a firm and allege, yes, you're an engineering firm. Yes, you need AutoCAD. Give me $5,000. Any engineering firm would cough up the money and go, here's your $5,000. Here's an extra $2,000 for your trouble. But when I find out it's a firm of 10, suddenly the damages number becomes substantial and becomes worth me chasing them. And in the interest of efficiency and being a good lawyer and managing my own billables, I could use the letters that I've prepared as precedents. So a matter like this, including settlement, I could probably knock over in 10 hours. So if I'm charging out at $4.50 an hour and I've got a paralegal or a junior who's doing all the background researching and liaising, I could probably bill the client maybe $10,000 to $15,000 per matter, and provided that I can get damages in excess of $10,000 or $15,000 plus maybe some compensatory on top, it's a win-win. I get paid, they get paid. So covering all bases, this is quite a good racket.
I probably have a slightly different view to Rebecca and possibly you as well there, Sam. I don't actually see this as a form of IP trolling per se. I see it as just basically you enforcing, your own rights against somebody who's stolen your intellectual property. When I was doing some research for this week, I was looking at some different things talking about IP trolling, particularly in America, where it seems to be lots of the stories. And it seems to be the true trolls, the true sort of villains, are not those who are in this particular situation who are trying to, I suppose, get some compensation for somebody stealing their property, but those who have developed a patent which is vague and generic and then go after all these development companies or invention companies or R&D companies who are building and producing something which has within it some form of that generic patent, but because the patent itself is so generic, it shouldn't have been patented in the first place. And essentially, they just go from the lawyers and the company who patented in the first place, go from company to company to company, issuing, letters of demand for settlements, even though as soon as it gets properly tested in court, it probably gets struck down straight away, but it never gets tested because the cost of litigation far exceeds that of settlement. So anyway, that's what I perceive the IP trolling of. Maybe this is interesting though, but yeah.
Yeah, I saw stuff on that as well. Did you see the case for Apple? I don't know if anyone saw that, GPNE versus Apple. It was like about a patent troll where Apple ended up winning. GPNE sued Apple in 2011 over 2 patents relating to the technology for communication across the cellular networks. And they said that Apple should pay $94 million for selling iPhones and iPads that infringed its patents. But that was including like its iPhone 4 and iPads and all that fun stuff. But Apple countered by saying that the technology covered pages which it didn't sell. So the jury ended up siding with Apple. And then apparently it says GPNE has threatened suits against hundreds of companies, including small businesses. So basically they were just going around with, all the patents that they own, trying to get as much as they could out of everyone. So I guess that's kind of similar to what you were saying.
Yeah, I mean, I don't see SAMS as really being a troll at all. I just see it as a fairly aggressive tactic to essentially seek compensation for your client who's had their property stolen, and it's a legitimate cause of action. I don't see it as trolling per se, because I would see trolling as you basically trying to sue somebody for infringement that doesn't even exist, if you look at it closely.
I think it's a sliding scale, and there's definitely grey areas in the middle. But one thing that I find interesting is, I mentioned it in the links there, a book that Stephen and I are using to try and change what we're doing in the law program called Tomorrow's Lawyers. And in the book, Susskind argues that the old style law jobs that law schools are preparing people for won't exist for too much longer. That most of the drafting and preparing documents for people will all be done online. And it's already beginning to happen. If you think about years ago, you used to go to a lawyer to have a conveyancing done. No one does that anymore that I know of. It's all done by conveyancing firms with software. But what Susskind says is we're actually developing new business models, and we're developing different ways of being lawyers. And I think what Sam's plan points to is a more adventurous style of lawyering, where you're not sitting in your office waiting for a client thinking, oh, there's a client going to turn up and come to me with a problem. We're actually proactively out there creating business. And the ethics of that's kind of interesting. And, I did tell you to be evil for this workshop, and that was certainly a pretty, maybe not evil, but pretty aggressive and interesting tactic. But it points to, and maybe the trolls are pointing to where business will be going in the future, where law is more interdisciplinary. It's not your solicitor's office who sits there waiting for clients, where you're actually going out there and you're creating business, and you're using skills not only as a lawyer but as an investigator as well. So I think this stuff, and I agree the ethics of it's really tricky, because the ethics professional standards are very glib. It's very easy to say, oh, you shouldn't do anything that's bad, or you should do the right thing by your client. You shouldn't do anything that's wrong or brings the profession into disrepute. But in reality, when the sort of rubber hits the road, those questions are really, really tricky for everyone.
Sorry, hi. In relation to your comment, Michael, about it being a really aggressive strategy or tactic, I see what you mean. And I do think it is quite aggressive and almost Dr. Evil-like. But I think the trolling aspect of it is that investigation type. It is that part where I actively go, I'm not being advised of an infringement, I'm seeking out the infringement. which is similar to the patent troll, who's going out and seeking Michael's infringement, Rebecca's infringement, Scott's infringement, maybe a subtle infringement or none, but he's having a crack. He's having a go. And this is Australia, where we have to have a punt at these things. That's how we are. So going after these companies and going to the extent of not only finding out, have you made an infringement? No, I'm going to research where I can find them, going to council, going to ASIC, going to LinkedIn, going all the way to those depths to cover my bases, to make sure when I pick the mark, they're going to pay. Because otherwise I'm wasting my time and my money, and I need a return on this. So yes, it's a very aggressive. Yes, 100% agree that it's got some serious ethical questions about it. It's almost ambulance chasing like. Legal? I mean, it's in the statute. Nothing says I can't do it unless I'm starting to exert undue influence or offending some other statute or rule. Then that becomes a problem. But it can be viewed as good advocacy. Could be viewed as protection of the rights of the copyright holder. It's probably not the most popular job to do, but it's a job and it exists. And that scenario is loosely based on an experience that I've seen. I was not the subject of the infringement. I was actually approached about the infringement, saying if you can give information, which is actually what prompted me to do IP law this term, because I was like, what the hell is going on? How is this even a thing? And then it prompted me to pick IP law as an elective, and I'm glad I did. So there are some things. Scott's just written, DX, here are some incriminating photos you might be interested in.
That's a discussion that's been going on in the window about this kind of adventurous approach to law. How would it apply to other areas of law? And I'm just imagining in the family law situation, going out there and proactively seeking incriminating evidence of marital breakdown, and then selling people on the divorce package that you are ready to provide for them.
I think that it crosses an ethical and a moral line.
I'm being, facetious about that, but it is fascinating.
But how is it different to this? How is it different to? So in my practice, I deal with builders and tradesmen who have contractual disputes and need basically like a quantum merit analysis of their job, and they bring people like me in and other colleagues. There's a big difference between when I ask the builder or the tradie, mate, if you've got anyone else on the job that needs my help, please pass my details along. And they go, okay. And then I actually start targeting jobs that are ran by the big builders and going to the job sites and giving up my business card and saying, hey, if they try to screw you, let me know, because I'll be ready. What we can do is 1, 2, 3, 4, 5. And as long as you keep this documentation, you get the foreman to say this. If we want to shake him down in a security of payment case or a statement of claim, or take him to the local court or the district court, you'll have all this information ready for me to go. Could that be trolling, or is that effective contract management? There's always a line it's always a question. And I think that lawyers tend to hold themselves to a high ethical standard in the interest of the public, yet it is that ethical standard that is also the chains to prevent them from doing other things and creating these private investigator hybrids. Look at the bar rules. It says you can be a barrister, but if you're something else as well, you can't win any work in that something else by saying you're a barrister. You can't let being a barrister influence your ability to win other work. Bullshit. I'm winning work because I'm a total package. Why can't I win work? And it's that ethical line. No. We must deliver a certain image and not bring the profession into disrepute.
So I'll direct this to Scott then. Scott, the scenario that Sam went through, the whole story, you probably have a better knowledge than we do on what like the solicitor conduct rules and that sort of thing say. Do you see that scenario as something likely to happen without it infracting upon any ethical rules? Does it toe the line, do you think, of what we currently have available?
I think it does. Look, the only people who I think would alert, who would possibly raise an alert here, would be if you were doing it without the knowledge of the IP holder, and if they thought what you were doing was a little bit greasy and they alerted the board, the practitioners board. That's the only scenario I can think of where they would even know that there was a problem, because as far as the marks are concerned here, you're acting on behalf of this corporation. So if you're going out there adventuring and you're drumming up business and you're going to the corporation, maybe they might go, oh, that's a little bit unethical, maybe we'll report that. But they may not either. That's the only situation I can think that would create, that would raise the problem. So in terms of ethics, it's less about oversight and more, I guess, about, people's own internal codes of ethics. And, it's that stuff I find really, really fascinating. And it's not something that we ever I covered in my ethics course. In my ethics course, it was just, don't steal your client's money and run off to the casino and spend it like all these other people did.
Are there any views on pro IP trolling? Is there anyone pro IP trolling apart from what would appear to be me on certain areas? But is there anyone else that sees a benefit to IP trolling?
Again, I don't know for the purposes of this exercise and this workshop, it was a really interesting approach. But I think what you've actually done is as Michael said, you've actually pulled yourself out of the trolling field by creating such a devious plan that you've actually got yourself covered, at least in terms of formal ethics, procedural ethics, in terms of what you're doing. And yeah, I'm not sure about the aggressive drumming up a business part of it, but I'm not making a judgment on that. But as I said, I think this may be what lawyers will be doing in the future to survive. Not necessarily actually creating traffic accidents to go and chase the ambulances for, but being a lot more in the community's face about what we do, and a lot more multidisciplinary in what you bring to the party, rather than being fairly passive and saying, well, give us your case and we'll go away and we'll give you some advice on it. Actually bringing in investigative and data analysis tools to the proceedings. So anyway, we're running out of time, but it's time for sort of final comments and observations. If not, that was great. That was really, really interesting, and that was exactly the sort of thing I hoped would come out of this. And honestly, where we talk about ethics, the grey stuff that's the interesting area, and that's the stuff that's really thought-provoking. Having a should you steal from your client or yes or no is a no-brainer, and that's not very interesting to talk about. But looking at this incredibly complex set of responsibilities and looking at the way society is changing and the business of being a lawyer is changing, it opens a lot. It asks a whole lot of very interesting questions. So thanks, guys. I found
the term troll a little bit hard to define. Troll, thank you, Michael. Troll, I found when you Google like the definition of troll, you got short little guy who lives under a bridge, and then you got somebody who leaves aggressive comments on Facebook and things like that. And when I looked for IP troll, I found the American, I guess, definition or rationale behind it. But IP trolling, I think, is a lot wider than just patents and technology and copyright. I tried to put myself in the mindset of a successful IP troll, somebody who's just nibbling at something until something bites and always trying to hit something. And that is, I think, in Australia, in our society and our community, that is the evolution of trolling. I had a consultant recently contact me saying, I heard that you've got a pro forma that you've developed for a government authority for the assessment of tenders. And I said, yes, I do. He said, I was just wondering if I could have a look at it. We're developing our own. I just wanted to have a look at it. In my head, I'm like, you're trolling. You're fishing. No. And then he called a colleague of mine and said, do you have Sam's, format? I just want to have a look at it to get an understanding. And he unsuccessfully contacted about 3 or 4 of my colleagues that I deal with. And in my mind, I said, is that IP trolling? And I was wondering if, Scott, you could answer that. Is that IP trolling or is that larceny?
Well, it's definitely phishing, isn't it? I mean, you have no idea what they're wanting to do with these things. But that's the thing. I mean, when we're talking about IP, when it's about ideas and when it's about expression of ideas, it's again the idea of property, which seems so unproblematic at the start. Let's call all this intellectual property, becomes quite much more complicated, because if people were sniffing around some of your actual property with the idea of taking it, it would be much more overt. If they were saying, hey, look, can I borrow the keys to your car? Because, I thought I might take it for a little bit of a drive. I'll bring it back. We know that's dangerous, but with ideas and expression of ideas, that becomes a lot more difficult. Yeah. It's been really thought-provoking, guys. I've really enjoyed this one tonight. Thank you.
Thank you very much. I want to thank Rebecca for all her help.
Thanks for arguing with me.
Before you guys go, have you guys seen the John Oliver last week tonight talk about patents? Have you managed to see that one yet? I'll put the link in the comments just because it's
that would be great.
You have seen it?
I haven't seen it, but I would love it if you could link me.
Yeah.
All right, there it is. I have a VPN on my computer so I can see any country, but hopefully that link still allows you to see it in Australia if you don't have a VPN. John Oliver is just a comedian. He used to work with The Daily Show. He's got his own thing on HBO, and he talked about patent trolls a couple of times, and there's one of his clips. So, yeah, it's pretty hilarious. Way to finish the night if you want to go watch that.
Cool, thank you. And I guess the last few things, next week's going to be the last week. It's all been over much more quickly than I thought it was going to. So remember, I'm keeping an eye on Digo. I'm posting some things up there in terms of your research papers, because time is, fast approaching that they need to be done. And this, just a reminder that this course is designed around sharing, and you get bonus points for sharing, not for keeping things to yourself. And by sharing, I mean posting links, but also discussing what other people have been posting and discussing ideas as well. So just a little reminder on that. Otherwise, remember that you can email me with questions and so on. And see you all next week.
I have a question. Do you want me to ask after the recording's finished, or?
Yeah, I'll stop the recording now.